The means here that Congress has chosen, the minimum coverage provision, is a means that regulates economic activity, namely your transaction in the healthcare market, with substantial effects on interstate commerce. And it is the conjunction of those two that we think provides the particularly secure foundation for this statute under the commerce power.
General, you've talked on a couple of times about other alternatives that Congress might have had, other alternatives that the respondents suggest to deal with this problem, in particular the alternative of mandating insurance at the point at which somebody goes to a hospital or an emergency room and asks for care. Did Congress consider those alternatives? Why did it reject them? How should we think about the question of alternative ways of dealing with these problems?
I do think, Justice Kagan, that the point of difference between my friends on the other side and the United States is about one of timing. They've agreed that Congress has Article I authority to impose an insurance requirement or other penalty at the point of sale, and they've agreed that Congress has the authority to do that to achieve the same objectives that the minimum coverage provision of the Affordable Care Act is designed to achieve. This is a situation in which we are talking about means. Congress gets substantial deference in the choice of means, and if one thinks about the difference between the means they say Congress should have chosen and the means Congress did choose, I think you can see why it was eminently more sensible for Congress to choose the means that it chose.
I'm not sure which way it cuts if the Congress has alternate means. Let's assume that it could use the tax power to raise revenue and to just have a national health service, a single payer. How does that factor into our analysis? In one sense, it can be argued if this is what the government's doing, it ought to be honest about the power that it's using and use the correct power. On the other hand, it means that since the court can do it anyway, Congress can do it anyway, we give a certain amount of latitude. I'm not sure which way the argument goes.
Let me try to answer that question, Justice Kennedy, and get back to the question you asked me earlier. I do think one striking feature of the argument here that this is a novel exercise of power is that what Congress chose to do was to rely on market mechanisms and efficiency and a method that has more choice than would the traditional Medicare or Medicaid type model. And so it seems a little ironic to suggest that that counts against it. But beyond that, in the sense that it's novel, this provision is novel in the same way, or unprecedented in the same way, that the Sherman Act was unprecedented when the court upheld it in the Northern Securities case, or the Packers and Stockyards Act was unprecedented when the court upheld it, or the National Labor Relations Act was unprecedented when the court upheld it in Jones and Lockwood, or the dairy price supports in Wrightwood Dairy.
Oh, no, it's not. They all involved commerce. There was no doubt that what was being regulated was commerce. And here you're regulating somebody who isn't commerce. Now, by the way, I don't agree with you that the relevant market here is health care. You're not regulating health care. You're regulating insurance. It's the insurance market that you're addressing, and you're saying that some people who are not in it must be in it. And that's different from regulating in any manner commerce that already exists out there.
Well, to the extent that we're looking at the comprehensive scheme, Justice Scalia, it is regulating commerce that already exists out there. And the means in which that regulation is made effective here, the minimum coverage provision, is a regulation of the way in which people participate, the method of their payment in the healthcare market. That is what it is. And I do think, Justice Kennedy, getting back to the question you asked before, what matters here is whether Congress is choosing a tool that's reasonably adapted to the problem that Congress is confronting. And that may mean that the tool is different from a tool that Congress has chosen to use in the past. That's not something that counts against the provision in a Commerce Clause analysis.
It's both necessary and proper. What you just said addresses what's necessary. Yes, has to be reasonably adapted. Necessary does not mean essential, just reasonably adapted. But in addition to being necessary, it has to be proper. And we've held in two cases that something that was reasonably adapted was not proper because it violated the sovereignty of the states, which was implicit in the constitutional structure. The argument here is that this also is maybe necessary, but it's not proper because it violates an equally evident principle in the Constitution, which is that the federal government is not supposed to be a government that has all powers, that it's supposed to be a government of limited powers. And that's what all this questioning has been about. What is left? If the government can do this, what else can it not do?
This does not violate the norm of proper, as this Court articulated it in Prince or in New York, because it does not interfere with the states as sovereigns. This is a regulation that But
that wasn't my point. That is not the only constitutional principle that exists. An equally evident constitutional principle is the principle that the federal government is a government of enumerated powers, and that the vast majority of powers remain in the states and do not belong to the federal government. Do you acknowledge that that's a principle?
Of course we do, Your Honor.
And that's what we're talking about.
And the way in which this Court in its cases has policed the boundary of what's in the national sphere and what's in the local sphere is to ask whether Congress is regulating economic activity with a substantial effect on interstate commerce. And here, I think it's really impossible in view of our history to say that Congress is invading the state sphere. This is a market in which 50% of the people in this country get their health care through their employer. There is a massive federal tax subsidy of $250 billion a year that makes that much more affordable. ERISA and HIPAA regulate that to ensure that the kinds of bans on pre-existing condition discrimination and pricing practices that occur in the individual market don't occur.
I don't understand your point. Whatever the states have chosen not to do, the federal government can do.
No, not at all.
I mean, the 10th Amendment says the powers not given to the federal government are reserved not just to the states, but to the states and the people. And the argument here is that the people were left to decide whether they want to buy insurance or not.
But, Your Honor, this is what the Court has said, and I think it would be a very substantial departure from what the Court has said, is that when Congress is regulating economic activity with a substantial effect on interstate commerce, that will be upheld. And that is what is going on here. And to embark on, I would submit with all due respect, to embark on the kind of analysis that my friends on the other side suggest the Court ought to embark on is to import Lochner-style substantive due process.
The key in Lochner is that we were talking about regulation of the states, right? And the states are not limited to enumerated powers. The federal government is. And it seems to me it's an entirely different question when you ask yourself whether or not there are going to be limits on the federal power as opposed to limits on the states, which was the issue in Lochner.
I agree, except, Mr. Chief Justice, that what the Court has said, as I read the Court's cases, is that the way in which you ensure that the federal government stays in its sphere and that the sphere reserved to the states is protected is by policing the boundary. Is the national government regulating economic activity with substantial effect on interstate commerce?
But the reason this is concerning is because it requires the individual to do an affirmative act. In the law of torts, our tradition, our law has been that you don't have the duty to rescue someone if that person's in danger. The blind man's walking in front of a car and you do not have a duty to stop him, absent some relation between you. And there's some severe moral criticisms of that rule, but that's generally the rule. And here the government is saying that the federal government has a duty to tell the individual citizen that it must act. And that is different from what we have in previous cases.
Well,
that changes the relationship of the federal government to the individual in a very fundamental way.
I don't think so, Justice Kennedy, because it is predicated on the participation of these individuals in the market for health care services. Now, it happens to be that this is a market in which, aside from the groups that the statute excludes, virtually everybody participates. But it is a regulation of their participation in that market.
Well, but it's critical how you define the market. If I understand the law, the policies that you're requiring people to purchase must contain provision for maternity and newborn care, pediatric services, and substance use treatment. it seems to me that you cannot say that everybody is going to need substance use treatment or pediatric services, and yet that is part of what you require them to purchase.
Well, it's part of what the statute requires the insurers to offer, and I think the reason is because it's trying to define minimum essential coverage because
— Yeah, but your theory is that there is a market in which everyone participates because everybody might need a certain range of health care services. And yet you're requiring people who are never going to need pediatric or maternity services to participate in that market.
With respect to what insurance has to cover, Your Honor, I think Congress is entitled to latitude in making the judgments of what the appropriate scope of coverage is. And the problem here in this market is that you may think you're perfectly healthy and you may think that you're not, that you're being forced to subsidize somebody else. But this is not a market in which you can say that there is an immutable class of healthy people who are being forced to subsidize the unhealthy. This is a market in which you may be healthy one day and you may be a very unhealthy participant in that market the next day, and that is a fundamental difference. And you're not
you're posing the question I was posing, which is that doesn't apply to a lot of what you're requiring people to purchase. Pediatric services, maternity services. You cannot say that everybody is going to participate in the substance use treatment market, and yet you require people to purchase insurance coverage for that.
When Congress is enacting economic regulation here, it has latitude to define the attributes of essential coverage. That doesn't seem to me implicate the question of whether Congress is engaging in economic regulation and solving an economic problem.
Are you denying this? If you took the group of people who are subject to the mandate and you calculated the amount of health care services this whole group would consume and figured out the cost of an insurance policy to cover the services that group would consume, the cost of that policy would be much, much less than the kind of policy that these people are now going to be required to purchase under the Affordable Care Act.
Well, while they're young and healthy, that would be true, but they're not going to be young and healthy forever. They're going to be on the other side of that actuarial equation at some point. And, of course, you don't know which among that group is the person who's going to be hit by the bus or get the definitive diagnosis.
So the point is, well, no, you take into account that some people in that group are going to be hit by a bus. Some people in that group are going to unexpectedly contract or be diagnosed with a disease that is very expensive to treat. But if you take their costs and you calculate that's a lot less than the amount that they're going to be required to pay. So that you can't just justify this on the basis of they're trying to shift their costs off to other people, can you?
Well, no, the people in that class get benefits too, Justice Alito. They get the guaranteed issue benefit that they would not otherwise have, which is an enormously valuable benefit. And in terms of the subsidy rationale, I think it would be unusual to say that it's an illegitimate exercise of the commerce power for some people to subsidize others. Telephone rates in this country for a century were set via the exercise of the commerce power in a way in which some people paid rates that were much higher than their cost in order to subsidize.
Only if you make phone calls.
Well, right, but everybody, to live in the modern world, everybody needs a telephone. And the same thing with respect to the dairy price supports that the court upheld in Wrightwood Dairy and Rock Royal. You can look at those as disadvantageous contracts, as forced transfers that I suppose it's theoretically true that you could raise your kids without milk, but the reality is you've got to go to the store and buy milk, and the commerce power, as a result of the exercise of the commerce power, you're subsidizing somebody else.
And this is especially true, isn't it, General Varelli? Because in this context, the subsidizers eventually become the subsidized.
Well, that was the point I was trying to make, Justice Kagan, that you're young and healthy one day, but you don't stay that way, and the system works over time. And so I just don't think it's a fair characterization of it. And it does get back to, I think, a problem I think is important to understand.
We're not stupid. They're going to buy insurance later. They're young and need the money now.
But that's
when they think they have a substantial risk of incurring high medical bills, they'll buy insurance like the rest of us.
But
I don't know why you think that they're never going to buy it.
That's the problem. Justice Scalia, that's exactly the experience that the states had that made the imposition of guaranteed issue and community rating not only be ineffectual, but be highly counterproductive. Rates, for example, in New Jersey doubled or tripled, went from 180,000 people covered in this market down to 80,000 people covered in this market. In Kentucky, virtually every insurer left the market. And the reason for that is because when people have that guarantee of that they can get insurance, they're going to make that calculation that they won't get it until they're sick and they need it. And so the pool of people in the insurance market gets smaller and smaller. The rates you have to charge to cover them get higher and higher. It helps insurance covers fewer and fewer people until the system ends. This is not a situation in which you're conscripting, you're forcing insurance companies to cover very large numbers of.
You could solve that problem by simply not requiring the insurance company to sell it to somebody who has a condition that is going to require medical treatment, or at least not require them to sell it to him at a rate that he sells it to healthy people. But you don't want to do that.
But that seems to me to say, Justice Scalia, that Congress, that's the problem here.
Yeah,
and that's
it's a self-created problem.
Congress cannot solve the problem through standard economic regulation, and I do not think that can be the premise of our understanding of the
whatever problems
problem.
Congress's economic regulation produces, whatever they are,
I think
Congress can do something to counteract them. Here, requiring somebody to enter the insurance market.
It's not a problem of Congress's creation. The problem is that you have 40 million people who cannot get affordable insurance through the means that the rest of us get affordable insurance. Congress, after long study and careful deliberation and viewing the experiences of the states and the way they tried to handle this problem, adopted a package of reforms, guaranteed issue and community rating and subsidies and the minimum coverage provision are a package of reforms that solve that problem. I think it's highly artificial to view this as a problem of Congress's own creation.
Is your argument limited to insurance or means of paying for health care?
Yes, it's limited to insurance.
Well, now, why is that? Congress could, once you establish that you have a market for health care, I would suppose Congress's power under the Commerce Clause meant they had a broad scope in terms of how they regulate that market. And it would be going back to Lochner if we were put in a position of saying, no, you can use your commerce power to regulate insurance, but you can't use your commerce power to regulate this market in other ways. I think that would be a very significant intrusion by the court into Congress's power. So I don't see how we can accept it's good for you in this case to say, oh, it's just insurance. But once we say that there is a market and Congress can require people to participate in it, as some would say, or as you would say, that people are already participating in it, it seems to me that we can't say there are limitations on what Congress can do under its commerce power, just like in any other area, given significant deference that we accord to Congress in this area, all bets are off, and you can regulate that market in any rational way.
But this is insurance as a method of payment for health care services.
Exactly. You're worried that's the area that Congress has chosen to regulate. There's this health care market. Everybody's in it, so we can regulate it, and we're going to look at a particular serious problem, which is how people pay for it. But next year they can decide everybody's in this market. We're going to look at a different problem now, and this is how we're going to regulate it. And we can compel people to do things, purchase insurance in this case, something else in the next case, because we've accepted the argument that this is a market in which everybody participates.
Mr. Chief Justice, let me answer that, and then if I may, I'd like to move to the tax power argument.
Can I tell you what the something else is, so while you're answering it? The something else is everybody has to exercise, because there's no doubt that lack of exercise causes illness, and that causes health care costs to go up. So the federal government says everybody has to join an exercise club. That's the something else.
No, the position we're taking here would not justify that rule, Justice Scalia, because health club membership is not a means of payment for consumption of anything in a market.
Right. That's exactly right. But it doesn't seem responsive to my concern that there's no reason, once we say this is within Congress's commerce power, there's no reason other than our own arbitrary judgment to say all they can regulate is the method of payment. They can regulate other things that affect this now conceded interstate market in healthcare in which everybody participates.
But I think it's common ground between us and the respondents that this is an interstate market in which everybody participates, and they agree that Congress could impose the insurance requirement at the point of sale. And this is just a question of timing and whether whether the necessary and proper authority gives Congress, because of the particular features of this market, the ability to impose the insurance, the need for insurance, the maintenance of insurance before you show up to get health care rather than at the moment you get up
to I think you're just,
get health care.
Unless I'm missing something, I think you're just repeating the idea that this is the regulation of the method of payment. And I understand that argument.
And it
may be a good one. But what I'm concerned about is once we accept the principle that everybody is in this market, I don't see why Congress's power is limited to regulating the method of payment and doesn't include, as it does in any other area. What other area have we said Congress can regulate this market, but only with respect to prices, but only with respect to means of travel? No, once you're in the interstate commerce and can regulate it, pretty much all bets are off.
But we agree Congress can regulate this market. ERISA regulates this market. HIPAA regulates this market. The market is regulated at the federal level in very significant ways already. So I don't think that's the question, Mr. Chief Justice. The question is there a limit to the authority that we're advocating here in the Commerce Power? And the answer is yes, because we are not advocating for a power that would allow Congress to compel.
Could you just say, before you move on, could you express your limiting principle as succinctly as you possibly can? Congress can force people to purchase a product where the failure to purchase the product has a substantial effect on interstate commerce if what? If this is part of a larger regulatory scheme? Is that it? Is there anything more?
We got two, and they're different. Let me state them. First, with respect to the comprehensive scheme. When Congress is regulating, is enacting a comprehensive scheme that it has the authority to enact, that the necessary and proper clause gives it the authority to include regulation, including a regulation of this kind, if it is necessary to counteract risks attributable to the scheme itself, that people engage in economic activity that would undercut the scheme. It's very much like Wickard in that respect, very much like Raich in that respect. With respect to considering the Commerce Clause alone and not embedded in the comprehensive scheme, our position is that Congress can regulate the method of payment by imposing an insurance requirement in advance of the time in which the service is consumed, when the class to which that requirement applies either is or virtually will certain to be in that market, when the timing of one's entry into that market and what you will need when you enter that market is uncertain, and when you will get the care in that market, whether you can afford to pay for it or not, and shift costs to other market participants. So those are our views. Those are the principles we're advocating for, and it's in fact the conjunction of the two of them here that makes this, we think, a strong case under the Commerce Clause.
General, could you turn to the tax clause?
Yes, thank you. So
I have looked for a case that involves the issue of whether something denominated by Congress as a penalty was nevertheless treated as a tax, except in those situations where the code itself or the statute itself said treat the penalty as a tax. Do you know of any case where we've done that?
Well, I think I would point the Court to the license tax case where it was denominated a fee and not a tax, and the Court upheld it as an exercise of the taxing power in a situation in which the structure of the law was very much